A man in Georgia worked his entire life building a house, a savings account, and a small business. He died suddenly at 58. No will, no instructions, nothing in writing. Within 6 months, his family was in court, fighting each other over everything he built. This happens to 67% of Americans, because 67% of Americans have no will. In this video, we're covering exactly what happens to your money, your home, and your family when you die without a will. Stay for the section on digital assets. Most people lose thousands of dollars here and never even think about it. First, dying without a will has a legal name. It's called dying intestate. When you die intestate, the state government decides who gets everything, not you, the state. Every state has an intestate succession law. It follows a strict order, and your wishes have no place in it. Spouse first, then children, then parents, then siblings, then extended family. If no living relatives are found, every single asset you own goes to the state government. Forever. Now, here's the first trap most people fall into. You're not married, but you've been with your partner for 12 years. You assume they'll get everything. They won't get a single dollar without a will. Unmarried partners have zero legal inheritance rights in most U.S. states. Zero. Regardless of how long you were together. The only exception is common law marriage, recognized in a handful of states like Texas and Colorado. If you're not in one of those states, a will is the only thing that protects your partner. Now, let's talk about what actually happens after you die without a will. The process is called probate. Probate is the court-supervised legal process of distributing your assets. Without a will, it can take 9 months to 2 years. And it costs money. Probate fees eat 3 to 7% of your entire estate value in legal costs. On a $400,000 estate, that's up to $28,000 gone in legal fees before your family sees a single dollar. And probate is public record. Anyone can look up what you owned and who got it. Now, children. This is where dying without a will gets most serious. If you have minor children and no will, a court appoints their guardian. Not you. A judge you've never met. That judge may not choose who you would have chosen. They follow legal criteria, not your relationship knowledge. A will lets you name the exact person you trust to raise your children. It's the single most important reason to have one. Now, the digital assets section. This is what nobody talks about, and where thousands of dollars silently disappear. Cryptocurrency held in a private wallet with no documented access credentials is gone when you die, forever. No court can recover it. Online businesses, digital accounts, domain names, subscription revenue, all of it legally inaccessible without documented instructions. A will can include a digital assets clause. It names an executor and documents where credentials are stored. Now let's talk about what bypasses probate, regardless of whether you have a will or not. Life insurance with a named beneficiary goes directly to that person. No court, no waiting, no fees. Retirement accounts, 401k, IRA, go directly to whoever you named as beneficiary when you opened the account. Jointly owned property automatically transfers to the surviving owner. No probate required. Bank accounts with a TOD, transfer on death. Designation goes straight to your named person instantly. Check every account you own right now. If there's no beneficiary named, that account goes through probate. Now, will versus living trust. A will tells the court what to do with your assets. It still goes through probate. It becomes public record. A living trust transfers assets directly to your beneficiaries. No court, no probate, no public record. A living trust costs more up front, $1,000 to $3,000 with an attorney. but saves far more in probate fees long term. For smaller estates, a basic will is enough. For anything above $150,000 in total assets, consider a trust. How much does a will actually cost? With an attorney, $100 to $500 for a basic will. Online services like Trust and Will, as low as $39. Compare that to the cost of not having one. Probate fees, legal battles, family relationships destroyed. There is no financial argument for not having a will. Here is your action plan. 5 things to do this week. 1. List every asset you own. Home, accounts, investments, digital assets, business interests. 2. Check every bank and retirement account. If no beneficiary is named, name one today. 3. If you have minor children, decide right now who you trust to raise them. Write that name down. 4. Document your digital assets. Passwords, crypto credentials, online account access. Store it securely with your will. 5. Create the will. Use Trust and Will online for $39, or consult an estate attorney for complex estates. 67% of Americans have no will. Most of them aren't avoiding it because it's hard. They're avoiding it because they haven't thought about it. You just spent 9 minutes thinking about it. You're already ahead of most people. Subscribe. Every week we break down one legal or financial topic that costs people thousands when they don't know it. Next week, UK Renter Rights 2026. What your landlord can and cannot do in the UK. I'll see you there.